Thanks everyone for joining us on this Tuesday. Welcome to our webinar today, Certificates of Insurance and Contractual Language with Teresa Severson. Teresa is the Vice President of Insurance and Risk at Retail Properties of America. Teresa, thank you for being here today with us. Before I hand it over to Teresa to introduce herself and to get started with her presentation, just a reminder, Teresa will be taking questions throughout the session and at the end, so you can pop those questions into the chat like we do. And she will answer those as they come up and at the end.
All right. Well, thank you, Rachel. I appreciate it. Thanks, everybody, for joining. And for those who attempted to join us in the last time we tried this, I'm sorry, my internet went down, which was unfortunate, but I'm glad that we could reschedule this for today. So we're going to go and talk about certificates of insurance and contract language and how they kind of relate and why they're so important. So let's see if I can get this to go here. So we have indemnification and insurance requirements in contracts. So, why are these important and really what are they? So the reason that you do any type of contract is to be able to mutually protect both parties to the agreement. And for contractors, suppliers, and vendors, it's to protect your organization from damage that they may cause in the scope of their work. It also puts the control of the work under the person who's in the best position, the contractor themselves. You're contracting with them or coming up with an agreement with a vendor because they're in the best position and have the expertise to perform the work that you guys are agreeing upon. And because they're the ones that are doing the work and they're the experts, they also have the best ability and are in the best position to control and have those safety control protocols put into place. So when you're doing all this, the idea of it is when you're protecting your organization, that if something should happen out of the scope of that vendor or supplier's work for you, then you have the ability then to tender the claim to them so that they're protecting and defending you, and thereby you're protecting your organization's loss history and you're controlling your insurance cost. So let's go ahead and take kind of a look at how this happens from a contractual standpoint. Retail Properties of America is a landlord. We own and operate open-air shopping centers and lifestyle centers. So when we're looking to hire a supplier, a contractor, when we're entering into a lease with a tenant, we are going ahead and we're going to issue an agreement, a contract with them for that work. The vendor agreement is going to clearly outline the scope of work, the location that the work is supposed to perform, and the dates and the times. So why is that important? The biggest thing to keep in mind is that when you're drawing up these contracts and you're looking at them and they're between two parties, usually there is, for example, in our situation, we're dealing with a property manager and then the account manager for the vendor or the supplier. And they're talking about, a scope of work that's to be performed. The agreement itself has to be written in such a way that a third party looking at it will have the same understanding that the vendor and the party that they're dealing with and contracting with has when developing this agreement for work. I always tell my field personnel to keep in mind that later on, if an incident should arise, a claim, rising out of the scope of work that this agreement is written for, will a third party fully have the same understanding that you two had when you were working on that agreement? You have to keep in mind that if a claim should happen, an incident should arise, it's going to be an insurance adjuster or it's going to be attorneys that are looking at this agreement to decide who's responsible for the damage that occurred. They have to be able to look at that scope and see what all the responsibilities of the vendor was, where that location for that work was to be performed, and what were the date and the time requirements for it. When we talk about location, and say you have a paving contractor, and later on somebody fell on a chip in the concrete that wasn't done correctly, we have to be able to go and identify exactly where that contractor did that work, so we know that if that trip and fall and that claim occurred, where they actually worked. We also need to know when that work occurred. Did it occur before this incident happened or after? That's going to be crucial. Same thing with security guards. What is their responsibilities? Where are they supposed to be patrolling? How often are they supposed to be doing it? Are there only certain days of the week that they're supposed to be there? Maybe they're there only on the weekends. If you have a snow removal contractor, is there a trigger on when they're supposed to be on site? It could be when the temperature drops below a certain degree, so that they're supposed to be out there looking for ice and salting the sidewalks. Is it the trigger to be when there's a certain amount of snowfall? So all of that has to be clearly outlined in the agreement. The final part about that is that you also want to make sure that you're including all the related entities. Again, the example for us as being a landlord is that we have the ownership entity for our shopping center. We also have a management company, and a lot of times there's a condo association that's involved. So are we making sure that we're protecting and listing all of those entities so that if there's a claim, because believe me, the attorney's going to look and get everybody that's at all connected to that property, and it's going to name them in the suit. So I want to make sure that that indemnification agreement that I have is going to defend all of my entities. Otherwise, they may accept tender for maybe the management company, but then I still have to hire legal representation for the association or the ownership entity if the contract isn't written correctly, so that the indemnification extends to all the parties involved. So I know that this, in this kind of arrangement, make sure that you guys know if you have any questions or I'm not kind of clarifying anything. If you want to, go ahead and make sure you send me a message in the chat, and I'll be trying to monitor that as we go through this. All right, so let's go on to the next page here. And we can talk about what is the difference between an additional insured and an indemnification clause. I think the problem that sometimes occurs in contracts is that people pay attention to one or the other, and you really need to pay attention to both. So the additional insured is when a third party agrees to add another entity onto their liability policy and provide them with benefits under that additional insured policy. An indemnification, on the other hand, basically is the clause that says that the party has the obligation to indemnify and defend the other party. Now, the difference is the indemnification clause creates the obligation, and the insurance is making sure that that party can meet those obligations under the indemnification because they have the insurance that's going to address that. So it's really making sure that that obligation can be met. So what does the additional insured endorsement under the policy provide? It provides that additional insured with access to the limits of the insurance of the first party's policy. It provides them with defense. It protects you against their insurance company coming back and subrogating against you and saying that we paid this claim, now we need you to reimburse us for your liability under this. It also can provide you with higher limits. For example, you could be a small store owner that hires a contractor to come and do work in your site, in your space. But you only carry $1 million in insurance because the exposure from your shop isn't that high. But a contractor, an electrician or so forth that's doing wiring within your space, their work has much higher risk to it. So they may be buying higher limits. By making sure you're entering into an agreement with them, you can be able to have access to those higher limits. It also allows you then to, transfer your losses, right? So instead of you having and your policy having to respond, the party that had control of the work is the one that's going to respond. So I think that, that's the thing to make sure that you're having, is that you want to make sure that you have a clear indemnification clause, and then you have the insurance that be able to back up that indemnification obligation under the agreement. So in looking at additional insured endorsements, how do you know what one is the right one? Because they're not all equal. There's a lot of different forms out there. A lot of different companies have their own manuscripted form. So how do you go ahead and make sure that everything that you're asking for is being provided by that additional insured endorsement? So let's go ahead and take a look at the certificates of insurance that they're going to be offering us. So in insurance, we like to have a lot of acronyms. So one of the certificates of insurance referred to as COIs. Sometimes you just hear certain brokers will just call them certs. Basically, they're all the same thing. It's a form that's basically doing nothing more than providing you with evidence of insurance. It's really important to note that the COI in and of itself, it doesn't convey any rights or any coverage to you. It doesn't list what the exclusions are in the policy. It doesn't provide you with the contract terms, and it's not going to take place of the insurance policy itself. It's really just a simple way and the least time-consuming way of being able to kind of verify that the obligations in the contracts have been taken care of through insurance. And it's an industry form that's acceptable. It serves as evidence. It indicates that the business has the financial resources, and it's just easier than reviewing an actual insurance policy. My organization itself, my team, we secure and review 5,000 certificates of insurance a year. If we had to read 5,000 insurance policies each year, I would have to hire 3 or 4 additional people. So when we're looking at the certificates of insurance, what are we looking for? And what may the additional insured endorsements read? There's a lot of limitations and there's a lot of different formats. So that's why you have to make sure that you're getting the right endorsement onto the vendor or the supplier or contractor's policy, and that it's being evidenced fully on the certificate of insurance. Some of the limitations that some standard endorsements have basically state that they're not going to ever provide you with higher limits than what is specified or required within the contract. What that basically means is that if my contract states that the vendor is to supply me with $1 million of liability, but they carry $5 million in liability, they're never going to pay me more than the $1 million I required in the contract. They also will state that the additional insured status only applies as if there's a written agreement in place. So that means that you have to have the contractual obligation, the contract, for an additional insured to apply. And you'll see a lot of times on the certificates of insurance, they're going to put that actual wording on there. They're going to say company ABC is an additional insured as required by written contract. So if you don't have the specifications correct in the contract, the additional insured endorsement isn't really going to do you that much good. Another limitation that's thrown in a lot, especially on carrier-specific additional insured forms, they're going to say that the insurance had to be required prior to the work beginning. So if you work backwards, which sometimes happens, a lot of times, there's standard procedures that are put into place, but if they get overlooked and then people try to back into them, and so that the contract is actually executed or they're set up as a vendor after the work's been performed, then the additional insured wording on that tenant's policy may limit you from actually getting the additional insured status that you think that you're getting. So I'm looking at this, and this is something that we created internally at RPAI. It is something that we outline as far as insurance requirements. And it's based upon trade type. So if you look down below, we tried to kind of capture the various types of vendors that we hire at RPAI for work on our property. And we've broken them down into 5 levels. The first level is pretty much your general catch-all, right? Pretty much everybody is going to fall into A. And we're basically saying that we require them to carry a minimum of $1 million in general liability. We require them to carry the statutory requirements under workers' compensation, and then the statutory limits of $1 million. We require $1 million of auto. If you are a locksmith or a property manager, we're saying that you need to have crime. And then if you go down to the right and you'll see columns B, C, D, and E, we're adding in specialty coverages. And these are for your professional trades like architecture, engineers. We're saying you need to have professional liability. We may say that for a demolition, or if we're hiring somebody to come out and do environmental phase 1 studies for us, we're going to require that they carry environmental coverage. We will, at the very end, those are our higher risk, or what we consider the highest risk of the vendor types that we hire. And those are going to be carnival operators and general contractors, and we're going to require them to carry $5 million minimum in general liability. A lot of times now, depending on the carnival operators, I'm requiring a lot more than $5 million. I'm usually requiring around $25 million. And by general contractors, those are the contractors who then hire subs to build out a building, usually from the ground up. So they oversee, and they're in charge of hiring all the different trade contractors. And then they're going to have agreements with them that require them, the subcontractors, to name them as additional insureds. But we're saying that the GC needs to indemnify us, meet certain qualifications for their subs that they're going to hire, and then they need to provide us with a minimum of $5 million. And that's usually going to be for an outlet that's going to be like a bank or a standalone restaurant. But if it's going to be anything that's multi-stories, that's usually going to go up significantly in the limits that we're going to require. So we attach this agreement to what we've created internally as an insurance rider. The reason that we created and we use this insurance rider is because of the fact that a lot of additional insured endorsements are going to have that written agreement qualification requirement for an entity to be named as an additional insured. So to do that, you have to have a written requirement, and without it being in the scope, and if it's something that falls outside of the scope of their normal duties, we have this on file for every vendor. And it basically says that if they do any work for us, and usually this is going to be issued through a work order, so there might not be a written agreement done for it. We have this on file, and it basically says that they agree to provide the insurance on the exhibit that we just looked at for any work that they do on our behalf. And then this is kind of a win-win for both the contractor and for us, because if I went out and required them to go ahead and give me a standalone additional insured endorsement that didn't have the written requirement agreement, most likely their insurance company is going to charge them a fee for that. The reason that they write a blanket additional insured endorsement as required is because it's easier for them to manage, right? They understand the type of work that this insured is going to do. They're a painting company. They know that they go out and they paint interior, exterior. There's usually a limitation by their underwriter of how many floors that they're going to go out. So they know the type of work they're going to do and the agreements that are going to be in place. But say we had somebody come out and we didn't do a contract because we just needed them to come out and touch something up. Maybe there was graffiti painted, and we said, can you come out and cover that up for us? Instead of issuing a full-length agreement to do that type of work, we would have a work order done, and then this insurance writer would create the contractual obligation that the additional insured endorsement under their policy would need. And if they were out there and then they spilled a paint and it hit somebody and there was an insurance claim that came out of it, this rider would allow me to be named as an additional insured under their policy and get the indemnification and the defense and being the ability to tender the loss to them as I would want to happen. So that's kind of how we created the contractual obligation to meet that wording in the additional insured endorsements. So if anybody has any questions on that, just either you can go off mute or send me a text message, however you want to do it. I know it's a little convoluted, and it's kind of another way of, basically a workaround to be able to meet that written requirement in most of the additional insured language. So on here, we have a standard Accord form certificate of insurance. Accord is the general accepted form of certificates. It is the industry standard that almost all brokers use to provide evidence of insurance. If you look at the certificate of insurance at the top, it will state that this is only information only and confers no rights or obligations. And then underneath where it says important, it basically says that it has to be endorsed correctly onto the insurance policy. Up in the very corner there, I'm sorry, I went up too. You'll see it shows where a date can go. That basically is going to be dated the date that the certificate of insurance is issued. Sometimes you'll get multiple ones. Sometimes they'll ask for a correction. So if you have two certificates of insurance, usually it's going to be the one that's the most recent that'll override the older one. And then you basically just have kind of the overall summary of the insurance program. So when we're looking at this, I see who the broker is that this insured is working for. And to the right of there, it's all their contact information. We here store that in our insurance and risk management platform that we record and monitor our certificates of insurance so that I know who to contact if there's any questions, if there's something wrong with the certificate, if it's going to be expiring, we'll reach out to them to ask for a corrected certificate. Below that, you'll see the insured. That's going to be your insured's name. You want to match up with that and make sure that it matches your agreement, your contract. Sometimes there's going to be a parent company that an affiliate rolls up into their insurance program, or sometimes a vendor is working under a DBA doing business as, and it may not match completely with your contract. You'll want to figure that out now. You don't want to figure that out after you have a claim to make sure that you have the right evidence and that you're named under the correct policy. And sometimes, you know, it is a matter of them just putting the description down in the description box lower of how the one entity is related to the other. But it's very important to make sure that you didn't get the naming convention wrong, and that your contract is the way that the policy is written. Over to the right of that, that's where they're going to list the various different insurance companies that the coverage that is evidenced is written for. As you'll see, they have insurer A, B, C, and D. If you look down to the lower section where they have the coverages written, normally a certificate should have, this only has one carrier on here, but if it had 2 or 3, that left-hand corner next to the general liability, auto, umbrella, workers' comp, would reference which insurer in that box is providing that coverage. We also use the insurer to look up their financial strength. It's provided by something that's called AM Best rating, and a lot of contracts will require that an insurance company that's providing the indemnification and insurance has a certain financial strength. Usually it's going to be no less than an A minus, and usually it's a size ranking of 7 or higher. So a lot of RMIS platforms that monitor certificates will automatically notify you if an AM Best rating falls below your standard. So that would mean that perhaps they feel that that insurance company is struggling, and you'll want to know that, especially if it's a large contractor you're working with. So those are things that we monitor. If you go down below, again, this is a standard form. The general liability, auto, umbrella, and workers' comp is pre-formatted into this Accord form. So the Accord form always has those there. And then the boxes to the right are filled out by the insurance broker. You'll see there's a column there that shows for additional insured and waiver of subrogation. I'll explain a waiver of subrogation in a little bit. But they can check off there that they apply to this additional insured. It has the policy information along with the effective dates, and obviously you want to make sure that those effective dates run through the term of your project or your lease. So if they issue a certificate of insurance and it shows they're about to expire, you want to make sure that you're following it up. If the job's going to take several months and they expire in between there, you want to make sure you get the renewal certificate. And then again, the final column, they're going to list the limits of the insurance that are carried on that policy. And this is where you're going to want to match it up to the insurance limits that are required within your contract. So there's a lot of back and forth looking at what's required and what's not required. The last box down here, you'll see that we have in there, it shows pollution or professional. That box is normally blank, and it allows the broker to fill that in as necessary with any additional coverages that may not be standard in the pre-printed form of the Accord itself. So this is where they can evidence the pollution or the professional liability. Sometimes if there is a requirement for them to carry some type of property insurance, instead of issuing a full separate certificate of insurance on an evidence of property form, sometimes they'll reference it in there. And again, this is all, you have the ability to manuscript that field so you can put in there whatever you need to put in. The same thing can be said down below under the description of operations. This is where they get to put in additional wording that kind of explains and makes sure that you can check all the boxes, that everything that's required is inputted into there. And then lastly, on this one that we're going to discuss, the certificate holder. That's going to be you, yourself, and you want to make sure that it has all the proper entities listed. As you see here, we have our management company as well as an ownership entity because we want both of them to be listed as a named insured. So a couple of things that we've kind of thrown out there with regards to requirements. We've used the word primary non-contributory, and we've used the term waivers of subrogation. So what do those mean? Basically, a primary non-contributory requirement in a contract basically says that the vendor's insurance responds first, and they're not going to be looking for the additional insured's insurance to share the limits or to share the liability limits. That their policy responds first to both defense and to settlement. And then the waiver of subrogation basically says that after the fact, the insurance company can't come back and try to subrogate against the additional insured for contribution. So we always require that we be named as an additional insured on a primary non-contributory basis, and that a waiver of subrogation should apply. So we want to make sure that all of those boxes are checked and all of those are provided. And again, if you look down below to the cert holder box, you'll see in this case, we've added 3 entities. We have a separate entity for the land, we have a separate entity for the ownership entity, and then we have a management company in there. So that's where we kind of refer to as making sure that you're getting everybody kind of provided coverage. All right, so we talked about additional insured endorsements, and there's a lot of them out there. I mean, we basically create a library that we can go ahead and look at general forms to look them up. And I always want to know where I don't want the full policy and I don't want to read the full policy form. I want to know that the additional insured endorsement that they choose to read or to apply is going to meet all my different requirements. So I will ask them to reference the form that they're using or to attach a copy of it so that we can read it and review it. When you look at an additional form and you're looking at standard ISO forms, they're coded in a specific way. If you look at the forms that I'm referring to on this page, they start off with a GC, so you know that that's a commercial general liability form, right, versus an auto form. The 210 refers to the form itself. And then the last 4 sets of digits, they're broken up there, 1185, refers to the addition form itself. So this one is the GC 2010 November of 85 version. If you look below, we have a 10-1 edition. Sometimes there's an April 13 edition. So there's different editions that are out there as ISO responds to requirements of insurance companies and as litigated case, and there's case law that are evolve out. A lot of these forms change, mature, put on limitations, and so forth. So you want to make sure what form you're going to be getting of each edition. The first one is a form that's going to provide you with both ongoing and completed operations coverage, and we're going to go through that in a little bit. The second one is that you need kind of 2 forms to be able to put them together onto a single policy to make sure that you're getting everything that you need. And then some of the older ones are a little bit more limiting in their scope, and so sometimes you need to be able to put on multiple different forms on there. And again, these are ISO standard forms, so these are industry standard forms, but a lot of your larger carriers are going to have their own form of this. So they may start with an ISO form and then build upon that with their own manuscripted form that gets approved then by the insurance commission. They have to be approved forms filed with the different states and federal, but you have to make sure that you're being able to get a copy of it so that you can read through them. So let's take a look at some of the ones that we've referred to here. So this is an ISO form. You can see that if you look down at the bottom. It says basically it's copyrighted by the Insurance Services Office. There's the insurance form number that I referred to. It says CG 2010-1185. Now this one is designed to be used for owners, lessees, or contractors. It gives you a space in there to input a specific entity or group of entities. A lot of times it'll say as on file, which means it's a blanket form that anybody that's been issued a certificate, their name is on file, they'll honor it. If you look at what the definition of insured here, it's basically says it's simple, right? Straight to the point. It's amended to include as an insured the person or organization shown in the schedule, but only with respect to liability arising out of your work. So as the additional insured, I'm willing to accept that because I'm not willing, I understand that they're not going to take on more at a job site other than what's their responsibility and what's in their scope. So when they say that they're limiting to their work, I'm comfortable with that. Here's another version of the same form. This is the 26, and this is basically then just for designated person or organization versus the other one that was kind of designed for owners or contractors. And it's saying the same thing, that it's limiting it to arising out of your operations or premises owned or rented to you, where this one here is saying out of your work. But basically they're providing the same type of coverage, just in different circumstances. Now, if you look at this form, this is the CG 2010, but it's dated 10/1, so it's October of 2001. And this form is much more limiting. If you look at the highlighted sections, they're saying that you're named as an additional insured. But that additional insured is only arising out of your ongoing operations. Then it goes on and it lists an exclusion under this endorsement. And it says that this does not apply to bodily injury or property damage occurring after all your work has been completed. And then the second part, your work has been put to its intended use. So what does that mean? I'm a landlord. I hire an electrician to come out and I ask them to do the wiring in my space. The technician is on site, and while they're working on it, they cause a fuse to blow and a fire starts. According to this, I'm covered as an additional insured because the fire started stemming from their work. Now, what happens if that same electrician does the work, packs up their tools, they leave, and I go ahead the next day, I come into the office and I turn on the light. There's a shortage and a slow short that then spreads a fire, and then I get a fire into my roof line. Under this endorsement, I'm no longer an additional insured for the fire and the damage that it may have caused to my tenant's property. And the reason that I'm not is because the work was completed, they had left the job site, and I put it to its intended use as soon as I turned on that light switch. So therefore, this additional insured status is not going to cover me. Now, when you have the CG 10-413 form, when you look at this form, and again, it's, you know, the same type of thing, scheduled persons, you know, you can list them in here. Who is an insured is anybody listed as an additional insured with respect to bodily injury, property damage, for your acts or admissions, those that are done on your behalf. And if you see down here again, it says for ongoing operations. But it says, however, coverage is provided to the additional insureds required by a contract or agreement. The additional insured is afforded coverage because of that agreement. So basically, if I'm stating that I require completed operations and it's in writing, it'll be extended over to me. So that's where making sure that your contract and your insurance requirements and the wording matches up. Because no insurance company is going to give away kind of free coverage, right? They want to make sure that you're requiring it in your agreement, and then they're going to transfer it over. But again, here it says with respect to insurance, these additional exclusions will apply, right? So it's all worker materials in connection with it have been completed or put on, right? So again, you have to kind of make sure that everything is matching up. And when you look at the next, I think we have one more. I thought we had one more. You basically want to have the one that you match these two up, where you're going to have this scheduled and then your completed operations endorsement that matches this, so that you make sure that you're getting everything covered. So I guess the thing that I want to convey most importantly is that just simply because you receive a certificate of insurance that says that you're an additional insured, you may not be getting everything that you need unless you're really truly reviewing it. So when you kind of look at this, so what are we, saying is important? And when you're looking at risk transfer, which is, a key tool for a risk manager, is transferring that risk to the appropriate party. So how do you safeguard that? How do you make sure that happens? And again, it has to be the matching up that you have the indemnification. So that is the requirement for them to indemnify you. How are they going to meet that requirement? They're going to have the right insurance in place. And then when you're asking them for insurance, just simply saying that they have insurance isn't enough. You have to make sure that you're requiring that A, they carry adequate limits, that B, they have the proper and additional insured endorsements that are going to apply to you on a primary, non-contributory basis for ongoing and completed operations, right? And then you want to have the waiver of subrogation so they can't come back to you afterwards. So when we're looking at it, you have to analyze what's the scope of the work that they're doing. Again, I may put it out and I may say that there's $1 million that's required, but perhaps, this is a smaller job and it's a smaller contractor, and maybe this guy is the most reasonable, or he's familiar with the property and maybe he doesn't carry something that our standard requirements meet. I have those discussions on an ongoing basis. I analyze the risk versus the reward, right? The lower cost, the person who's familiar with the shopping center perhaps. So I need to take all of that in consideration. Also, if I'm in a smaller regional area, maybe it's more rural and they don't have as many contractors available, maybe I have to accept something that's a little bit different. But the one thing that I don't take in mind is what the cost of the job is. Just because somebody's charging me, $5,000 for a job versus $100,000 doesn't mean the work that they're doing isn't more risky. It's the same thing with a tenant. I could have a 5,000 square foot tenant that sells different types of baseball caps, or I can have one that has a small space with inflatable jumpies that kids can come into and play in. Same square footage, maybe I'm going to get the same rent, but the exposure is not the same. And I always need to keep, in mind that a situation is unique. Things don't always fit into a perfect box. So that's what the job of the insurance professional is, whether you're an underwriter or you're a claims manager or you're a risk manager. You have to be able to take everything into consideration to fully evaluate it. Because there's going to be some things that are the cost of doing business, and they just can't be transferred. So you're going to have to take on some risk. You have to just determine what is acceptable to your organization. And every organization's risk tolerance is going to be different. So it's working within those parameters that makes basically a risk manager's job so interesting and challenging. So we went through a lot. I know that. We had 45 minutes to do it. Looks like I'm 45 minutes on the dot. So I ran through a lot of this. If there's any questions, I'm happy to answer them now. I think we have a few minutes for that. Also, if you look, I do have my contact information. So you're always free to reach out to me with some additional questions. And I think that's about it. Rachel, do you have anything?
No, this was great, Teresa. Thank you so much. And folks, if you don't have the chance or a pen with you right now, you can always reach out to me and I can send Teresa's contact along as well. Teresa, this is separate from the topics that you just covered, but I'm curious, I know you mentioned to me briefly before everyone else got on the phone of your experience with RPAI and the riots right now, and I wonder if you wouldn't mind speaking to your experience with what we're dealing with right now.
So RPAI, we own shopping centers across the country. We have centers in New York and Chicago, Washington. Those are the areas that have been primarily impacted. You know, as a landlord, most of the damage that occurred, unfortunately, is on the tenants, because most leases put the responsibility for doors and windows on the landlords. On the tenants and the repairs of those. So my intern, who's a Spencer grant intern, I'm very excited to have Alex on board, has been working with us and first tracking, what centers had planned protests or seen protests. So we were tracking that. Then we were tracking which tenants had to board up. And then now that the tenants have started to take those boards down, as a landlord, we have concern that in putting up the boards, they cause damage that, if not repaired correctly, could cause water infiltration that could then lead to mold issues and other types of damage. So we're now reaching out to those tenants and helping them to make sure that they're making those repairs in the correct way. Some of our centers, they prepared for the worst, then didn't get anything really. Everything was pretty peaceful. We had other ones that did experience some looting. And again, that falls through the lease to the tenant, to the loss that they would have had to any of their interior and their goods that may have been ransacked or stolen, which is, troubling, because they had been possibly not open for a while due to COVID, and now they were starting to get reopened, and now they're, dealing with the next thing that's on the list, dealing with the riots. But we've been working with our tenants. We've been working with, peaceful protests, and working with the cities and the different municipalities on how, best to respond and be prepared for anything that could happen. So, that's kind of what we worked through a lot on the month of June. And now we're just in the process of getting everything kind of back into order.
Great, thank you for answering my tangential question. All right, everyone. Well, if there's no more questions, again, I can forward you along Teresa's contact. Just feel free to reach out. Teresa, thank you so much. This was really wonderful, and thank you for taking the time to be with us today and share all of your wealth of knowledge with this group. It's much appreciated. For those of you here, FYI, this is a double webinar week for Spencer. So we are also going to meet together on Thursday. If you're available, we'll be hearing from Jamie Sewell, who is the Senior Manager of Risk Management and Insurance at Boeing. So I hope to see you on Thursday.
Rachel's real sorry. If I have time, I did get one quick question.
Yeah.
Alex is asking if I have advice for somebody who wants to start their career in risk management in the property management sector. So, Alex, a lot of times, and if you already are doing an internship or working at them, I think, just always making sure that you're aware and that you're willing to help out. I work very closely with multiple departments within my organization. I don't work just and look at it strictly as what we're buying insurance for, but as an overall risk management. I'm always dealing with our operations team on the construction end and the repairs. For example, right now, even though through these riots, none of the damage that occurred was landlord responsibility, I'm still working with property management and with operations on how these tenants can get back up and running and how they need to make the proper repairs. So is that really an insurance claim? No. But is it something that we need to kind of be able to get them up and operating and generating rents and sales? Also, but making sure that we don't get future damage by getting water infiltration and then having to deal with mold issue a year from now, and then wondering how that water got in. And it got in because we didn't address the issue that we see here. Making myself available to the marketing department. I work with the marketing department a lot. They hold special events. How can I make sure that those events are held in the safest and most secure way? One is by having agreements with people that are participating in the special events. If it's a tenant that wants to have an event on our property, or a third party that's coming in, or if we're hiring somebody, I'm working with them to make sure our contracts has as much risk transfer as possible. I'm also working with them, and maybe they're not setting it up in the best location. Is that going to block traffic flow? Did they, consider where, what the parking is going to be, what the porta potties where they need to be. There's all those little different things that need to kind of be considered. So it's kind of making sure that you're making yourself available to everybody within the organization. But I think as somebody young that's kind of starting off, is asking the right questions of the right people, not being afraid to ask questions, making sure that they know that you have an interest and that you have a skill set and that you have the ability to add something to it. And a lot of times with a lot of these departments is how is that going to affect their bottom line? I work a lot with property managers because I can show them that there was a number of trip and falls in a certain parking lot, and maybe I can help them and give them information about the claims that we paid, and that gives them the dollars that they need from a budgetary standpoint to get those repairs made. So I think that would be a good way. And again, my contact information is there. So Alex, feel free to reach out to me and we can talk more specifically about your role and see if there's any other ways that maybe I can help you out. So that's it. So thank you, Rachel. Thank you to Spencer Group. Thanks to everybody who tuned in, and everybody have a good day.
Thank you so much, everyone. Thank you, Teresa.
Okay, bye-bye, guys.
Bye, everyone.